Okay, everyone, we are back, and we will proceed now to the third panel of the day. And our keynote speaker helpfully helped tee up one of the issues that we'll focus on this afternoon, which is the role of carbon capture and sequestration in the CDR milieu. Right? Obviously, CCS has an independent role to play in terms of point sources, but it's also obviously a critical component with many of the CDR approaches that we talk about, including BACs and DACs. And so what we wanted to do in this panel was take a snapshot of where we are in terms of the CCS regulatory environment. And so I am going to turn it over to my favorite cohort in crime on CDR, the co-director of the Institute for Carbon Removal Law and Policy, Simon Nicholson. Simon, the floor is yours.
Thanks, Will, and thanks to everybody who is with us today. It's been a fascinating first couple of sessions. Welcome to session 3 of our third annual conference on carbon removal law and policy. My job is to very quickly get out of the way and let our 3 panelists launch into their presentation. So let me just introduce them very quickly. First, we'll hear from Kristen Hite. Kristen is currently serving as legislative attorney at the Congressional Research Service. We'll then have Carolina Arlota, who's at the Sabin Center for Climate Change Law at Columbia University as an associate research scholar. And our third speaker is Priya Prasad, who's a senior attorney with the Commercial Law Development Program in the Office of the General Counsel of the U.S. Department of Commerce. So Kristen, over to you. If you'd like to extend the introduction a little bit by telling us a little more about yourself before you launch in, that would be great.
That sounds great. Thank you, Simon. And hello, everyone. So as Simon said, I'm a legislative attorney at the Congressional Research Service. Before diving into today's topic, I wanted to give a quick public service announcement on CRS, which many people are not familiar with. You can think of us as Congress's own nonpartisan think tank. We're a federal agency of the legislative branch, and we're housed in the Library of Congress, and we provide exclusive services to members of Congress and their congressional staff. Anyone in Congress can ask us just about anything, and CRS will field that question to specialized analysts, attorneys, and librarians. And we do our best to quickly provide an objective and authoritative answer. I'm one of the attorneys at CRS, and I generally field questions on environmental law and international law. Our services on these requests are strictly confidential, so I can't really discuss the specifics of any given question, but we do make some of our research public when it's of general interest to Congress. In that capacity, I will talk today about some of my research on the federal legal framework for carbon dioxide capture, transport, and storage. So I will share my slides. And let's see, I start the presentation. So here we go. So as we talk about the federal legal framework for CO2, hold on just 1 minute. I want to sorry, Simon, can you give me like 30 seconds? There's something going on with my PowerPoint here.
Oh, of course.
If you wanted to introduce any of the other panelists, maybe while I'm troubleshooting this, I would be very grateful.
No, I think we're just going to watch you sweat, Kristen.
All right, even better. Sounds good. So I'm going to try stopping the share and see if that makes a difference.
Okay, so try one more time, and if we need to step in and share from our side, we have your
share
as well.
All right, let's try one more time. There we go. I think we got it that time. All right. So what I'm going to talk today about is the federal framework. And so not the state framework. And the federal framework is fairly limited. And so here's the spoiler alert, just kind of the take home. There is no comprehensive federal framework. Instead, there are various laws, agency funding, permits, and infrastructure that affect different aspects of various activities associated with capturing, transporting, injecting, and attempting to store carbon dioxide. My goal for this presentation is to offer an overview of many of these federal elements, starting with the laws and the agencies that underpin them, and then moving to specific dimensions such as infrastructure siting and operational safety. We'll then very briefly touch on some of the limits of federal jurisdiction by looking at some of the areas where state laws have more detailed legal frameworks. For all the lawyers, non-lawyers out there, it probably bears mentioning that we don't have just one legal system in the US. A lot goes to the states, and thanks to our Constitution, there's only so much that the US Congress can do about matters that are governed primarily under state law. But Congress can do a lot when it comes to federal agencies of the executive branch that are overseen by the president. The US Congress makes federal law, agencies issue regulations, and judges adjudicate all these rules. And so that's our federal framework. I'm going to limit this discussion to geological storage of carbon dioxide and the legal dimensions there. Obviously, there's more to it on the international front, on the surface front, and in other areas, but I'm going to speak specifically to the geological dimensions. So let's start by looking at some of the federal laws that Congress has enacted related to storage, capture, transport, and injection. At CRS, we don't tend to say CCS specifically because those different functions have different pieces in different laws and agencies. Congress makes two types of laws. Some authorize activities and some pay for authorized activities. We have both here. Public law, for example, Public Law 116-260 created the Energy Act and the Use It Act. This was both in 2020. So the Energy Act expanded research and development support for carbon capture, storage, and utilization at the Department of Energy. It did things like create new prize funding for direct air capture technologies and offered policy direction to support removals. And then we have appropriations acts that have put money towards those prizes. The Energy Act of 2020 also authorized Department of Energy to support removals, not just for direct air capture, but also things like bioenergy with carbon capture and storage, enhanced geological weathering, terrestrial sequestration through agriculture and forest, and planned or managed carbon sinks. But what I'm going to talk about more is the Use It Act and direct air capture, as well as more use pieces. So that's the Use It Act. That provided some guidance to Department of Energy for carbon capture and utilization technologies. Use It also amended FAST 41, that's referenced in the third bullet here on this slide. And that's another example of authorizing legislation. Thanks to Use It, carbon capture infrastructure projects are part of covered projects for FAST 41 that we'll talk about in a minute. And those enhance coordination of environmental reviews and permitting for certain large infrastructure projects. Some even more recent bills than this 2020 bill include the Infrastructure Investment and Jobs Act and laws commonly referred to as IRA and CHIPS, CHIPS in science specifically. Buckle up in this presentation for some acronym soup. It's about to get bumpy between this and the next slide. I will try to bring myself in, but please feel free to use the question and answer box if any of my sentences start to sound like Morse code. All right. IIJA, the Infrastructure Investment and Jobs Act, that supported a carbon utilization program and carbon dioxide transportation, infrastructure, finance, and innovation program. It also made some amendments to Department of Energy's CCS and CO2 removal programs, and it provided supplemental funding through 2026. The CHIPS and Science Act, the part we're going to talk about is the science piece and not the CHIPS portion of the law. That has a section that promotes innovation in carbon storage in addition to carbon utilization research. And then we have IRA, the bill commonly referred to as the Inflation Reduction Act, scaled up tax credits for carbon capture, utilization, and storage activities. I want to take just 1 minute to talk about these tax credits that were amended in recent years by some of the earlier legislation. Since 2008, Section 45Q of the Federal Tax Code has allowed a credit for carbon capture and sequestration equipment and facilities. Thanks to IRA, a transferable credit now of up to $60 a ton is available for carbon oxides that are injected underground and used to extract oil, and a higher premium is available for longer-term storage in places like deep saline formations, gas reservoirs, and unminable coal seams. The credit lasts for 12 years, and it has to be repaid if CO2 escapes back into the atmosphere. Credits can be maximized if they meet wage and labor requirements, and less is available per ton if they don't. A growing number of federal agencies are becoming involved in carbon capture, transport, and storage activities. We've already reviewed some of the laws supporting R&D funding. These are frequently administered through, say, Department of Energy. We talked about the 45Q tax credits. Those are administered by the IRS. But there's also our federal land management agencies. They do some related to surface storage that we're not getting into. But just last week, the Forest Service threw its hat in the ring with a new notice of proposed rulemaking to allow it to receive applications for a special use permit that would allow activities seeking to undertake long-term storage on Forest Service lands. In a similar vein, last year, the Bureau of Land Management, that's at Department of Interior, they issued a new policy on rights of way for CO2 pipelines. And then we have agencies like PIMSA and FERC that are involved in CO2 pipelines, while others like EPA, the Council on Environmental Quality, and the Federal Permitting Steering Council, Improvement Steering Council, those get into some of the permitting in CO2 storage efforts. We'll talk about that in a minute. Before we get into those details, though, it's kind of a whirlwind tour of the federal laws and agencies. It showcases a diverse array of federal actors and activities. That said, there are plenty of cases where the federal dimension might be fairly limited compared to the role of states, local governments, and the private sector. Part of this diversity is because CO2 itself has multiple uses, and legal considerations of that depend in part of what we're talking about. What is CO2 exactly? I mean, beyond one carbon bound to two oxygens, right? Consider that it wasn't even until 2007 that the Supreme Court considered whether the Environmental Protection Agency has the ability under the Clean Air Act to regulate carbon dioxide as a pollutant. Turns out it does. And while we have that clarity, some things are still, forgive the pun, up in the air. For example, is carbon dioxide a liquid or a gas? Well, in the atmosphere, as a pollutant, it's a gas. When it's respirated by plants, the carbon gets detached and it's converted to stick plus oxygen, right? And while most folks think of CO2 as a gas and as a naturally occurring substance, the Federal Energy Regulatory Commission has said it's not the kind of natural gas that's covered by the Natural Gas Act, which has implications for how much the federal government can regulate it. FERC also has specific rules for natural gas pipelines that have been when those pipelines are repurposed for CO2 transport. So then FERC has jurisdiction. When CO2 is underground, we've got early federal decisions that carbon dioxide is treated like a wild animal. It's wild until it's captured. When it's flowing through a pipe, it's typically cooled to supercritical form, and then it's some kind of blend between liquid and gas. And when it's injected underground, it's regulated under the Safe Drinking Water Act. And then we have the question up in the air of, is CO2 a product or is it a waste? Sometimes it's a valuable product. It's not just used by plants to breathe, but also in production and manufacturing for everything from putting bubbles in our soda water to extracting oil and gas from the ground. In the early 20th century, the federal government was already contemplating leasing out rights to carbon dioxide. And as early as 1936, Department of Interior authorized leases and associated royalty payments of carbon dioxide. And now we have the IRS administering tax credits to put it back in. So we've got a little bit of all of these pieces. But if it leaks above ground or if CO2 leaks out from a pipeline, it could become hazardous and it could make people sick. It could even kill them or kill animals. And so all of these different uses affect how CO2 is legally treated. I'll use the rest of my time today to unpack more of what this means for permitting, drinking water, and property rights. While states generally govern land use and property considerations, the federal government can get involved in CO2 infrastructure related to permitting and pipelines. Details can be project specific, and for the federal government to be involved, there has to be some kind of federal hook. And it's not always intuitive what that hook is. First, for permitting and environmental review, and this is limited to, we're talking about things within US borders that involve a federal agency. There's a lot more at the state level beyond the scope of what I'm talking to you about today. But at the federal level, we have the National Environmental Policy Act, NEPA, which requires federal agencies to consider environmental impacts of their decisions and to issue an environmental impact statement if its impacts are significant. For permitting, some projects may, for carbon sequestration, may be required to obtain permits for specific activities. For example, the Clean Water Act requires permits to fill a wetland or discharge a pollutant into water of the United States. The Endangered Species Act has specific requirements for project proposals that could affect threatened or endangered species in their critical habitats. And then the Safe Drinking Water Act that we'll get into in a minute gets into more detail about what's required to inject CO2 into the ground for projects that require both an environmental impact statement and another permit. We've got FAST 41. I mentioned that earlier. That allows for coordination between agencies. It sets up a timeline. It's supposed to allow projects to go through within 2 years and allows for more coordination between agencies and potentially also with the states. And CO2 infrastructure is can be a covered activity under FAST 41. But honestly, a lot falls to the states. And so I wanted to talk a little bit now about what that can look like. I'm going to talk briefly about when CO2 is in the ground, how it works under the Safe Drinking Water Act. We've got various legal frameworks to navigate, and we've mentioned it already, but it serves to say again, states typically have primary jurisdiction over property and land use. And I know we don't have a lot of time, so I'm not going to get into a lot of details, but suffice to say, the Safe Drinking Water Act does have a specific permit for Class 6 wells that is fairly detailed. It has a 50-year framework for long-term compliance for siting and permitting. And so that's what would be required at the federal level to be able to inject carbon underground. And then we've got property rights and state laws. And this is where there's a lot more to be said. There's not a lot of time to get into the details of this, but the land that's where everything's located is generally going to be governed by the states and not the federal government. If it's federal land, that's a different story. But ownership and pore space is going to be very state specific about who owns what, who absorbs the liability, who gets the benefits, who's entitled to all of those credits. And a lot of that's going to be sorted out in the courts as we go. We don't have time. I wish I had more time to get into the details. This really is kind of a whirlwind of the federal overview, but I hope this does give you a sense of all the different flavors of ways that the federal government might. I am available for questions later, and Simon, back to you.
Thank you, Kristen, for walking us so succinctly and expertly through such a treacherous terrain. We're turning now to Carolina. So moving from the US context out to CCS and removals under the Paris Agreement. Carolina.
Thank you, Simon, for such a thoughtful introduction. Thanks, Kristen, for a delightful conversation. Thanks also to all the organizers, especially Will Burns. Just a quick moment where I want to have this as a slideshow. So the topic that I would be presenting is what the current data can actually tell us. And it's a regional survey of current national determined contributions and long-term low emission development strategies. The national determined contributions are mandatory under the Paris Agreement. The LT, which I will use the acronym here, shortened one, are only suggested and are expected, particularly under the Glasgow Pact, to be aligned with the national determined contribution. So I just want to briefly clear that out to the extent that they are all in the title, but NDCs are mandatory, LTs are expected to, are encouraged, but are not mandatory, and they address policies after 2050. So I would like to clarify that this presentation does not reflect the views of the Sabin Center for Climate Change Law. And also would like to acknowledge that Caitlin Carpenter, as in her role as a summer intern within the Sabin Center, did the direct data collection for this research, for the sample, under my supervision. So those two main caveats that I would like to underline. The outline for today's presentation, so a very brief background and overview about some basic concepts pertaining to this research, then basically a bit of a contextualization within CCS, CCUS, removals under the Paris Agreement. Bear in mind that the goal of the Paris Agreement, obviously, is to achieve this balance between emissions and removals, right? So we can still hopefully stay with 1.5 degrees Celsius. That's the key main temperature goal, although, best efforts on that, but the threshold being 2 degrees Celsius. On part 3, I will actually introduce more details about surveys and findings, and then some thought-provoking, hopefully, notes and preliminary conclusions. So those are obviously controversial topics. I am Brazilian, so I would like to clarify that when we talk about Global South. I think it's important for the audience, for those who do not know my background, to know a bit on that. And CCS, CCUS, and removals in general are not here being presented in any way as a panacea, meaning a cure for all, particularly the carbon dioxide concentrations levels, greenhouse gases more broadly, that we are having in the atmosphere, but as one of key actions in the portfolio to reduce and to achieve the climate goals under the Paris Agreement. So we've seen the temperature. Let me just remove that as well so you can see the full slide. The temperature anomaly, basically human influence, and it keeps growing. It keeps getting warmer and warmer. And that's pretty much the carbon dioxide concentrations per part. And we can see a spike after the 50s as countries keep ultimately producing industrialization and so forth. So I want to quickly introduce some of the notions underlying carbon dioxide removal. This is actually a domestic definition, and I would like to highlight that currently the supervisory body under Article 6.4 of the Paris Agreement is discussing actually what should be removals to qualify for the market-based mechanism under 6.4, and I think this definition is quite illustrative, although it's a US definition from the English government, basically to highlight that it's a wide array of approaches, some of them natural-based, as we have reforestation, and others engineered-based approaches, such as direct air capture, which is kind of like very promising in terms of the percentage of capture of carbon dioxide. When we talk about carbon capture and storage, I would use the IPCC definition itself, which is carbon capture and storage is a process meaning it's not a single particular one shot. So there are several activities involved, in which a relatively pure stream of carbon dioxide from industrial and energy-related sources is separated, meaning captured, conditioned, compressed, transported to a storage location for long-term isolation from the atmosphere. A point that I would like to highlight is not just the complexity involved in this CCS, but also that there's not a single takeaway or a single definition, if you will, in terms of how long the carbon dioxide capture needs to be stored. So from 100 years to 1,000 years, that still remains to be clarified. And there's been a lot of discussion on that, but clearly long term. So the big picture here, trying to briefly underline the distinction between CCS and carbon capture usage and storage. So CCS versus CCUS. And it's very, Kristen made my job a bit easier here when she mentioned that usage part could be whether for industrial uses, so think about enhanced oil recovery, or food and beverage industry. So this is different than when we think about carbon dioxide that is stored in the ground. And here it's important to underline that CCS and CDR, for the purposes that we are talking here, they have both this component of long-term storage. And I hit the mouse to underline, and then it went for the next slide. So I would like to briefly highlight that we've seen, when you think about major polluters, we've seen the US reducing actually its emissions for different causes, particularly energy efficiency, if you will. And we're seeing obviously the rest of the world increasing, and we've seen particularly India and China bringing among those high polluters. And obviously China is the current emitter. And historically, though, is still the US. So when we talk about the Paris Agreement, as I mentioned earlier, this underlying emissionality, there needs to be a balance between anthropogenic emissions by sources and removal by sinks. Hence, my interest in CCS, CCUS, and removals to the extent that it's within the Paris Agreement framework, and obviously the higher concentration of greenhouse gases in general in the atmosphere, and obviously carbon dioxide. So national determined contributions, as you know, and I mentioned earlier, they are mandatory, and countries are supposed to offer them to, under the United Nations Framework Convention on Climate Change, Secretariat submit through that through every 5 years, although they can adjust that and submit earlier. The goal is to have emissions inventory and include those very clearly, and there's a methodology for that, the so-called IPCC guidelines on that. And the general premise also for this research was the limited number of countries actually mentioned CCS and CCUS. In their removals, there are more countries mentioned, and CCUS in their national determined contributions, although removals are more popular, particularly reforestation. So I also want to highlight that there are often contradictory information regarding the number of countries that actually mention CCS, CCUS specifically in their NDC. So that's why when I designed this research, I had that in mind. And also there's a lot of, I wouldn't say, information that can be improved. Some sources will cite, for instance, Iran, and the country is not even a party under the Paris Agreement. So that's obviously complicated. So Glasgow Climate Pact also, and subsequently Sharm el-Sheikh, both have this very push from developed countries to phase out unabated coal, while developing countries, or if you were north versus south, pushing for phase down one. When we talk about phase down unabated coal, that's coal without CCS. So we've seen under the IPCC reports, International Energy Agency, this need for actually having CCS and carbon dioxide removal technologies being used to actually achieve the goals of the Paris Agreement. And we have a major breakthrough, if you will, when it comes to the Paris Agreement. Oh, I hit something that I last slideshow. Okay, here we go. And then what happened was they basically did not submitted their specific contribution. So I want to highlight, going back a bit because I lost the thread with the PowerPoint, the Glasgow Climate Pact was when parties agreed actually to the so-called Paris Rulebook, implementing Article 6 mechanisms, specifically at least the basic framework. Of course, details are yet to be discussed and will be coming next December, COP28. So against this background, we will move forward to the actual research, the actual survey. And it is an original one, and I look at 30 member states of the Paris Agreement, basically 8 member states of 7 member states of the Paris Agreement plus the European Union, so which is obviously not a state, but just as jurisdiction, but I will use just member states generally. I use national determined contributions and LT, so long-term low emissions as mentioned earlier. And this is basically the countries that are part to the data set. So in blue, you have the European Union countries that integrate the data set. So total 30 countries, 8, including the jurisdiction of the European Union plus 7. So that means we are not going for qualitative analysis, but I really want to study what is actually there. So what they are actually saying. And the first line of inquiry was to see international comparative approaches. So this is general, not just for the 30 countries. And I want to call our attention to the countries in kind of like dark blue, so countries that are considering or intending to use international market mechanisms, so Article 6 mechanisms, market mechanisms to actually fulfill their national determined contribution, because ultimately that is a hint that they may use CCS or other aspects of particularly engineered-based removals. So I actually looked at the data and I want to highlight. So on your left side, you will see, let me move this here, our main findings when it comes to Article 6 market mechanisms. So what are the countries that are actually saying that they will not use Article 6 market mechanisms, base mechanisms? So basically Iceland, Norway, the USA, and all the countries within the European Union. So, you know, from our data set, that's 11 member states. So why is it important? Because it shows that the EU countries, obviously, the US and Schengen's agreement countries, the European Economic Area are aligned on that. That's Norway and Iceland also. So basically saying we will not use those market mechanisms to fulfill the national determined contributions. Then we have 3 interesting countries that did not touch the issue in their national determined contributions, and that's China, India, and Iraq. If you think about developing nations of the Global South, or basically the so-called basic countries, so that would be Brazil, South Africa, India, China. I mean, you have 2 of those players saying will not even mention that. So they were particularly silent about the use of NDC to fulfill, not particularly silent about Article 6 mechanisms to fulfill the NDC, their NDC. When we look at countries that are saying, okay, we will use, we are considering to use in such Article 6 mechanisms, we have the list. We had 16, and including Brazil, including, let me move here, the Zoom bar, so we can actually highlight Russia and South Africa. So at this point, I want to say there is no such a thing as Global South, like this packing. It's difficult to have in mind here. So as we move forward with our findings when it comes to national determined contributions, specifically looking at removals, we have 15 countries plus all the countries within the European Union, and it's saying that they will use carbon dioxide removals. And you see the colors here, it's to highlight, like yellow, we have China, that it's the only country in our survey that actually mentions that it will use CDR, CCS, and CCUS. Then in green, we have the countries that are overlapping, saying that they will use CDR and CCS, that's Iceland and Switzerland. And in bold, as you can see, Canada, Indonesia, Iraq, Morocco, then Pakistan, Republic of Korea, Saudi Arabia, and United Arab States, basically saying that they use CDR and CCUS. So again, a bit of divide, although we still have EU and US quite aligned. So findings when it comes to the long-term strategies under the Paris Agreement, we have, like, from the sample of countries, we have 6 countries that did not submit long-term strategies, and you have them up here. And then we have 24 countries, so the remaining countries, so all countries that submitted the long-term, so basically their policies from 2050 afterwards, they are considering removals. And CCS, carbon capture and storage, all of them. 2 exceptions, Russian and Republic of Korea, that did not mention CCS, but did mention CCUS. So I think it was also important to highlight. So I have the provocative title here for us to highlight some of my conclusions, the preliminary findings, if you will, when it comes to the current data. So is there a global South pattern when it comes to national determined contributions findings or long-term emissions? So we clearly cannot say, to the extent that there is a pattern, to the extent that China is basically saying that it will not use, for instance, market-based approaches under Article 6 of the Paris Agreement. And China, as I mentioned earlier, was the only country saying that it will use removal, CCS, CCUS. So again, we also have the division between South Africa and India. So South Africa being in line more with Brazil. So again, strategic behavior on countries and different, and I think also this speaks to the limitations of the so-called Global South denomination itself. A quick point when it comes to the European Union, why is it CDR but not CCS, CCUS in the party's national determined contributions? So basically they acknowledge the use, see that it's important to have CDR, general removals, but they did not specifically address CCS or CCUS. When it comes to national determined contributions. And this is probably by political reasons. There's a lot of still reluctance, if you will, in different member states of the European Union when it comes to CCS, so not in my backyard considerations, but also there's a lot of uncertainty to the argument, and also the so-called mitigation deterrence interpretation domestically, particularly in Germany, for instance, that would be an issue. But on the other hand, they have to acknowledge that that might be important after 2050. So probably for political considerations, then this will be one explanation. When it comes to the US, that it's also mentioned carbon dioxide removals, but also not using CCS, CCUS in national determined contributions, but mentioning in long term. So it's a bit trickier, and obviously the political environment here is less, although there is a resistance, but it's significantly less resistant than in Europe when it comes to CCS, CCUS in general. So conclusions, very preliminary about this data. So we clearly can see some strategic behavior of countries in their national determined contributions and long-term strategies. Basically, what they are conveying, what they are signaling now when it comes, for instance, to market-based mechanisms. So we see particularly the EU and US aligned on that, saying they will not use such mechanisms under Article 6. We're seeing EU and US very aligned in terms of preponderance of removals in long-term and national determined contributions, but also not mentioning CCS, CCUS. We're also seeing different approaches when it comes to the Global South. And I think this speaks specifically to the topic of this overall conference, which is basically, the notion that it's no longer just domestic law, domestic energy law versus international energy law, and it's often the underlying so-called energy trilemma, where countries have to reconcile their growth, their current access to energy resources, but of course there are general obligations under climate agreements, right? So this tension between how to reconcile brings this local, global, and global versus local influence. Of course, once Article 6, Sustainable Development Mechanism is actually implemented and kicking, then that might change. There might be a change in terms of NDCs and the role, actually how countries are welcoming particularly CCS and CCUS, and trading carbon, of course, when it comes to, would that be a net negative country? We know Bhutan now it's the only one, but is it possible to have all the jurisdictions that have particular influence in the world, setting different states? And we know also Morocco has been very ambitious in terms of the alignment of the goals of the Paris Agreement. So all in all, more work needs to be done, also considering the current NDCs. And of course, I did not use the statistical analysis here, but I think that's also prone to with the use of AI for data sets and so forth. So thank you so much. I look forward to answer your questions. And thanks for this opportunity to share my work.
And thank you, Carolina, for being with us. So our final presentation is from Priya. Priya, do you have a slideshow? Yes.
Great. Thank you so far, both of the panelists. Really great discussions. And I think what I'll essentially be doing is continuing the international discussion that Carolina just had. So let me just start by maybe describing a little bit about the group that I'm with, which is within the U.S. Department of Commerce. I'm with a group called Commercial Law Development Program, CLDP, and we provide legal and regulatory technical assistance to developing countries around the energy transition dilemma. We're getting more and more questions around CDRs, CCS, CCUS in emerging economies, which is where our technical assistance focuses on. And some of the items and the challenges that Kristen talked about that we're facing in the US, they're also kind of grappling with at the same time at this, like Carolina mentioned, there's a lot of opportunities to learn from other countries, other parts of the world. So I think the main part that I'll be talking about today and giving a couple of anecdotes from what I've seen with my work, particularly in Southeast and South Asia, is the role of coordination cooperation in spurring CDR and CCS, CCUS in the global South. As with regular disclaimer, the comments and views that I'll be presenting are personal anecdotes that I've observed in my role, not those of my employer, the US government. So let me just start with talking a little bit about legal and regulatory policy framework. So all three of us come from a legal background. And I know we have non-lawyers also on the call. But the concept of having a regulatory framework for CCUS has been discussed. Back in over a decade ago, the IEA developed a model framework. This is a document that's published and available for download now. And at that time, they pulled from existing frameworks from jurisdictions, including some states, the federal government, the US side, some countries in Europe and Australia. And now fast forwarding to 2023, it's pretty clear that model framework has still not been finalized or developed. So there's been activity and development at different stages. So the EU primarily relies on their CCS directive from also around the same time period. We've talked about the federal government programs and a little bit of the state through Kristen's presentation. And then, the Australia and Canada have relied less so on their national framework, but more on their regional local framework. But they've also been able to develop their own domestic regulations. And what we're seeing with ASEAN is, at least in the last couple of years, an acceleration of framework development, both at the country level and also at the regional level. And one anecdote I'll share for those of you tracking the work overseas, and I know, Carolina, you tracked Indonesia in your survey that you just shared to us about. So Indonesia did launch their own CCUS framework back in March of this year. And it's been headline and drawn a lot of attention from ASEAN partners in the region, who have really seen Indonesia step up and be one of the more forward-leaning countries in the region to develop a framework and attract that international investment. So this could be, U.S. businesses, other international businesses who are doing capture direct or point source at other countries, and then needing to identify a long-term permanent storage hub. And Indonesia naturally has a lot more long-term storage capabilities than their domestic emissions. So kind of leveraging the natural resources that the country has, they've launched their framework. There are some gaps, and the country has acknowledged that and plans to release essentially a presidential decree later this year, which will address some of the topics that I saw pop up in the chat, and hopefully we'll have some time to talk about. And one is sort of long-term liability on the storage side, whether it's CDR point source or direct air capture, that's the source of the CO2 that's being stored. What happens? Does the operator have to have an obligation to maintain monitoring and kind of surveying of the storage facility for hundreds of years? If they've left the site and they've demonstrated with satisfactory data or modeling that there's no migration of the stored CO2, can liability transfer? So that's one aspect I think Indonesia and others in the region are going to start looking at, in addition to transport. So I mentioned that, Indonesia, there's some other countries in ASEAN too, as well as others in the world, that have the ability to accept CO2 because they have natural storage. In other countries, on the flip side, they have their domestic emissions, but they don't have storage, so they need to transport out. So then we have kind of the challenges of cross-border transport, whether that's usually through maritime, the economics of doing that, but also, and I think our next panel is going to talk about marine life and sort of the treaties and protocols that you have to comply with when you start talking about transporting CO2 across international waters. But all that to say is, like I mentioned, there's no uniform global framework to address legal and regulatory issues around long-term storage and transport for CO2 that's captured, point source or direct. And the question that I ask to everyone is, well, does it matter that there's no uniform framework? And I don't think, just to answer that question, I don't think there is a problem. As long as the work is being done at the country level and there's coordination being done, which I'll give a couple of anecdotes how I've seen coordination being done, we are making some progress towards some harmonized framework. So I wanted to primarily spend some time today talking about a tool that I came across, which before I had heard about this, it was fascinating to me that there's a wealth of resources available right now to countries at the government level, but also to private industry. So some of you on the call may be familiar with the International Standards Association, ISO. So ISO has many, many standards around different topics, including GHG emissions, MRV, and the like. But about a decade ago, 2011, ISO developed a committee dedicated to CCS, CCUS, and that is ISO, and TC stands for Technical Committee 265. And as you can see on the slide, there's a number of working groups covering the full value chain. So there's a working group specifically led by Japan currently that focuses on all aspects of capturing the CO2. Germany leads the transport working group, which primarily, my understanding, focuses on non-shipping transport, because we do have the Norwegians leading the shipping working group. And then there's one led by Canada on long-term storage. Working Group 4 on monitoring reporting has now been split across all of the different working groups. So even though there's a country assigned as the working group lead, it is possible for countries to participate in any number of these different subcommittees. Let me just start as by giving some background about standards generally, and this is applicable for standards beyond ISO, but also talking a little bit about ISO. So what do I mean by a standard? So a standard is very different from a rule or a law. So in general, standards are developed by member consensus. They are not mandatory. So there's that difference from the regulation or a law. So if a country has a regulation or a law, that takes precedence over the standard. However, the role of the standard now is if there's an existing regulation or law that's silent, a standard could be used to be adopted into that law or regulation, and it could be adopted in whole, the whole text of the standard, or in part. But even if there's no law or regulation, there's a blank sheet of paper that a government is working off of to develop a framework for CCUS. The presence of a standard that has international buy-in, like ISO TC 265, could be very helpful to elevate that standard and get buy-in for that country to adopt a regulation. So I mentioned that ISO TC 265 is comprised of subject matter experts. So ISO itself does not write the standards. It is the experts within the countries. And these are experts from both ministries, NGOs, the state-owned national oil and gas companies, or other kind of hard-to-abate sectors who are interested in this topic, regulators. So it's a very broad list of participants who are writing these standards. And the countries participate at essentially the approval level. So there's a level of voting membership that a country, through their national standards body, so in the US it is ANSI, can basically sign up for 265 and then approve the standards. So there's about 6 published standards right now that 265 has published, and every 5 years these are updated. So there's a chance by joining as a member for a country to have access to the previous versions and also have a participatory role in the development when that standard is being updated and revised. And this role, I think, is really critical because even if a country chooses not to adopt the standard, perhaps it's not relevant to them, maybe they're not doing storage in country, or maybe they don't have the necessary buy-in. By participating and having a seat at the table and providing their input to other countries as part of the update process, that results in a more enriching document that can be used globally. So I also mentioned that, this is a resource that can be used by the private sector. So in the case of a standard addressing a topic that a private industry wanting to go into a country and do a CDR, CCUS project wants some guidance. Say, there's let's just take a international oil and gas company wants to go into, Indonesia and do a CCS storage project where they have captured the CO2 at their own facilities. And in addition, they've also done some direct air capture. They've done the necessary transport, and that they're now at the border. Now, that company may be looking to that country's regulations on what to comply with. And if a country does not have anything, or it's lacking sort of detail, then that company may be able to look into a known standard that's generally gotten that industry or international acceptance, like ISO, and demonstrate that they're following the minimum requirements of that standards, and present that to, say, the regulator in the country. So just to talk a little bit about the membership of ISO, I mentioned that it's the national standards body in the countries that can join. They can join as either a voting member or the non-voting member. And then there's another role where they can join as a liaison member, where they don't have a voting say, or not, they don't really contribute to the standard or not being adopted, but they do have a fairly persuasive role. And this is where the NGOs, private industry, can typically participate. But you can see there's a decent representation by many of the countries active in this space, in this organization. And the best part is this is there's no membership fee, there's no cost to join. So our organization has been sharing this existing resource to many of the countries that are looking to develop CDR, CCUS frameworks, and asking them if they're interested in having a seat at the table free of charge to, at minimum, just get more information and learn from other countries who are maybe a little bit farther along. So I've shared ISO as a tool in the toolbox for a country that can put together a legal framework and potentially use the resources and develop the relations to harmonize with neighboring countries. This slide, and I won't get into the detail of it because I want to make sure we have some time for questions. So this slide gives a little bit of some factors that countries who are developing legal frameworks consider. And you can see there's a lot of decision making, whether a framework should be at the federal level or at the subnational level, whether the state-owned entity who has a big role to play should have a seat at the table, which is the ministry or agency involved. So Kristen talked about, in the US, the bifurcation in some cases of states versus the federal government. Should it be the environmental ministry, or should it be the hard to abate ministry, the energy ministry that's involved in the regulatory role or some other role? Financial incentives like 45Q equivalent or loan programs, are those things that should be in a framework, or should they be addressed separately? Access liability, which tends to be two of the sticking point, and then international treaties, complying with things like London Protocol to the extent a country is wanting to do cross-border transport. Should that be addressed in the framework itself, or is that a separate instrument? In general, I think what I've seen most effective, especially for a country that wants to get up and running quickly, is choose the path of least resistance. If you're going to have easier buy-in from the stakeholders, the public stakeholders in your country, to get some regulation done at a subnational level and then scale up, then start there. And if it's the ministry that has some knowledge about this technology, overseeing it initially, then have them play a significant role. I'll just leave with this slide, and this sort of is similar to what Carolina presented earlier in terms of the role of different countries, but I wanted to share this just to show, in my opinion, sort of the growth and why our office is focusing a lot on Asia Pacific at this time. So this was taken from the Global CCS Institute's report. And for those of you who are not subscribed, just an unsolicited plug, they have a wealth of great resources on CDR and CCUS, all available for free subscription. But you can see from here, after North America and Europe, it's really Asia Pacific that is growing in terms of the number of facilities, whether that's different, saline formation, depleted oil and gas reservoirs, basalt formations. So in our opinion, that is sort of the region that we're tracking and looking to see how they can best coordinate when they're developing these frameworks. So with that, Simon, I'll turn it back to you. I think there were a couple of questions in the chat, but over to you.
Thank you, Priya. And Kristen and Carolina, can I invite you to turn your cameras back on too if you're with us? Excellent. Thank you all, fascinating, very rich. Just to let everybody know, the presentations will be uploaded once they're captioned within a few days. You can find information about all of our resources at carbonremoval.info. That's the Institute for Carbon Removal, Law and Policy at American University. We have about 15 minutes for quick responses to a number of questions. So Kristen, can we start with you? The kind of highest level question is, what's going well when it comes to US regulation, and what are the big gaps?
So those are interesting questions. What's going well? My job is to provide research answers for Congress. So we work in a bipartisan basis and a nonpartisan basis. And so what one person says is going well, another one may say is going poorly. So I will decline to answer that question respectfully and withhold my own personal judgment. And then, Simon, there was a second question.
Well, you might withhold judgment on this one too, but where are the big gaps? Where does work remain to be done?
So CRS has identified that in the past we have characterized kind of a regulatory gap, if you will, in some of the siting pieces. For example, with respect to where are you citing carbon dioxide pipelines, there is a projection that carbon dioxide pipelines are anticipated widely to scale up potentially. They're just in the last 2 years. In the Midwest alone, we saw 4 pipeline proposals that would almost double. Those 4 would almost double existing CO2 pipeline infrastructure in the country, just for those 4 projects. And so the question of where do you cite it and what are the permitting dimensions? This came up for natural gas, and Congress responded by saying, well, then when it comes to natural gas, we're going to have the Natural Gas Act, and the Federal Energy Regulatory Commission is going to be making decisions, and this is a federal issue. That has not been the same approach with carbon dioxide. And so there is just a wide variety of questions about where do things get cited and how does that get addressed.
I'll pull 2 questions out of the chat that seem related to that point, Kristen. So one is the observation that most pipelines will be interstate. And so do you expect that things will just get hung up as states quibble over how best to sort through regulatory regimes? And then there's a second question from Brad Warren. Do you know of anyone who has evaluated the extent to which tribes are regulating underground storage on their land or on federal trust lands held on their behalf?
I saw Brad's question about the tribes. I thought it was a really interesting one. I do not know the answer off the top of my head, but I think it is a good question. Tribes can also have, they could consider Class 6 applications and administration. Right now, I'm only aware of a few. I know that there were some other questions about Class 6 wells, which is kind of the EPA's Safe Drinking Water Act permitting scheme. I'm not aware of tribal applications for that specifically, but I do think that those are some really interesting questions. As for interstate pipelines, what I could say is this. There are some safety questions. There's 2 federal dimensions that are pretty clear here. One is the Federal Energy Regulatory Commission for natural gas pipelines that are repurposed for CO2. There is a role for FERC to play. The other is for safety considerations. There was a leak back in 2020 in a town in Mississippi, a CO2 pipeline leak that wound up, there were dozens of people that wound up in the hospital, and PHMSA, the Pipeline Hazardous Materials Safety and Health Administration, the PHMSA wound up issuing new, there's a lot that's under consideration now. Last year, there were draft regulations that were issued. I understand last month there were 17 members of Congress that sent a letter to PHMSA asking for more oversight and regulation, and there's just a lot of consideration over what is going to go on with pipeline safety. And all of that is following this 2020 line rupture. So my understanding is that PHMSA does plan to publish a notice of proposed rulemaking in June of 2024, but that they've not set a date for a final rule for that. And sorry, I know I said 17 members. I think it was 13 members of Congress that wrote to President Biden asking, they specifically asked for a moratorium on any federal permitting of new carbon dioxide pipelines and related infrastructure until PHMSA's safety regulations are finalized. So that is just one dimension of the pipeline, that and kind of the FERC piece are 2 dimensions that do have federal components to it that we have some information about.
I have 1,000 more questions, and we've got a number of questions coming in, Kristen. We won't have time to get to them all. Our practice at the Institute is to gather up these questions, feed them back to panelists, and invite written comments if the panelists are willing to provide that, which we will then post along with recordings of the session. So I invite folks to look out for that. Let me bring in Carolina. Carolina, I was struck by a few observations out of your study. The thing that stood out to me most was this idea that you're seeing strategic behavior, as you called it, based on your analysis of long-term strategies. I wonder if you can just speak a little more about that. What should we read from that observation of strategic behavior?
Thanks, Simon, for the opportunity to clarify. So I think it's wonderful question and gives me the opportunity not only to clarify what I've defined as strategic behavior. So I'm actually borrowing from Kutter and Yolen definition of strategic behavior, basically saying what the others will decide as their own course of action based on relying on whatever the others are playing will decide. So the classic example is if you think about swimming, there's nothing, or climbing a mountain, there's not, the mountain won't change its behavior or the water won't change because you decided to swim or to climb the mountain. But if you're playing soccer, American football, whatever that is, you will have to consider your offense or defense according to, if you're playing a team that is stronger in offense or defense. In summary, and sorry for the digression, but I think it helps to clarify for the non-lawyers and specifically in the audience, so that's the technical definition, right? And I think it is illustrative of the energy trilemma again, and that speaks to the broader topic of this conference, which is we cannot just think about energy law in general as domestic law, right? And countries have to fulfill their international obligations under climate agreements, yes, but that has consequences in their domestic policies. And we've seen, regardless of the presidency, of course, particularly under this presidency that has the current administration that's very focused on climate considerations, rejoin the Paris Agreement from among other actions. But I think it's they are considering not only their own potential economic advantage or protecting the climate, because it's clearly seen that it pays off, but also they are considering to send a message to the extent that the atmosphere is a global commons, right? So if everybody pollutes, and this also speaks to when you think about the role of climate change and how it's the quintessential collective action problem, right? So if a particular country decides to reduce their emissions, but others are not doing, so that's, it has an impact, but it's not significant in terms of the atmosphere. You may play strategic. But what I really want to emphasize with the conclusion about why countries might be willing to say that they will use removals and CCS in the long-term strategies, meaning after 2050, it's because politically, they don't have to go through the hurdle of domestic considerations to commit to that on the national determined contributions. So by 2050, it will be another administration, it will be other players and other governance in different countries. And you also don't want to you don't want to commit to something from an international perspective and then do not obey the standards that you set for yourself, right? So remember, national determined contribution is voluntary. Those are voluntary actions, right? So the countries decide how to formulate. So why would they overcommit or risk not fulfilling their obligations that they ultimately are setting for themselves, right? I'm not sure I answered your question, but I'm sure I passed the time for the answers. So.
You answered I think the spirit of the question very usefully. Thank you. And it also, of course, calls into question or brings to the fore one of the provocations that we heard out of the keynote address from Joe Romm, just about the promises that are being made. If you make a promise for action 50 years from now, and somehow we're basing current decisions in the strategic environment on those promises, and that raises all sorts of questions about what some have called the moral hazard, or what you referred to as mitigation deterrence, Carolina, in your presentation. But I do need to move to Priya. So thank you. And Priya, can I bundle just a couple of questions for you? We have a couple of questions about who exactly is getting involved in ISO type standard setting in this area. And so to be more specific, have you come across examples of Indigenous, First Nations, or tribal governments being involved in these processes, or how can non-governmental organizations help with the development of standards?
So officially in the voting, there's 3 levels of membership. There's the participating member, which is a voting member, and then the observing member, which is non-voting. But in both of those 2 categories, the membership has to be by the national standards body within the country. So there's essentially 1 member per country, assuming there is a national standards body that's already been kind of coalesced. There is a 3rd category, which is liaison. And in that category, there are NGOs who already are members. So that is an option for non-standards bodies to join ISO. Going back to the first two categories, it is possible for a country to nominate some industry expert or an NGO expert to participate under their membership, broader membership in one of the 7 working groups, because typically the standards body is not going to know about all of the topics that ISO is publishing standards on. So they're going to rely heavily on the subject matter experts within their countries to do that. So for example, in the US, ANSI is our national standards body, and they have joined as a participating member, but there are several US industry members who have joined as experts in one of the 7 groups. In terms of the indigenous tribes, I am not sure exactly whether they've officially joined in one of those capacities, but I think the role of consortia and those broader organizations can be very effective. Perhaps if there's organizations like that, they may be able to participate in a liaison capacity.
Great, which leaves you 2 minutes, Priya, to tell us if there's anything else you'd like to call our attention to when it comes to productive examples of coordination and cooperation. You mentioned that you're seeing a few different things emerging internationally. Is there something else you'd like to call out for us?
So I think the main thing is there's, especially in the ASEAN region, and we're getting more inquiries, I think also in Africa, there is a huge appetite for information, and I think, and learning. So what I've seen in this community is there's a lot of interest in learning from others, both the positives and negatives, and understanding that, not everything is translatable. So those who are experts on the call, getting involved in forums like this that have participation across, that we have international audience members, I think these can be very effective. So continuing to stay abreast of these kind of opportunities and raise your hand to provide, be a speaker in some of these events. I think getting the conversation going can be very helpful.
Thank you, Priya, Kristen, Carolina. Wonderful panel. And back to you, Will, to set us up for the 4th session after a short break.